Okay, let's unpack this. Think about your everyday life for a second. You order something online, right? Or maybe you hire someone, a freelance designer perhaps.
Or sign up for a gym membership even.
Exactly. All of these involve contracts. And, ideally, everything just goes smoothly.
Yeah, the perfect scenario. Your package arrives on time. It's exactly what you wanted.
The design work. Flawless, delivered when promised.
The gym gives you access. You use the facilities. The contract just runs its course.
And then it's done. That's performance. Successful completion.
But of course, life isn't always like that, is it?
No. What happens when the package is late or damaged? What if the design work is, well, just not up to scratch?
Or the gym suddenly closes down, leaving you high and dry.
That's when things go wrong. That's breach.
And understanding how these agreements actually end, either nicely through performance or less nicely through breach, is absolutely fundamental. It's core contract law.
It really is the mechanics of how contracts work, or sometimes how they fail.
And that's precisely what we're diving deep into today. Performance and breach.
What does it actually mean to perform a contract? What if your performance isn't, 100% perfect?
What actually counts as a breach? And crucially, what are your options if the other side doesn't hold up their end of the bargain?
Lots to cover, and this deep dive, it's built upon some excellent educational materials.
Yes, materials made available by the University of London. And we really want to stress right up front, this discussion is purely for educational purposes.
Absolutely. Our aim is simply to help you get your head around these key legal principles, understand the main cases, and see how these ideas work in practice.
And we're absolutely delighted that this deep dive is brought to you by Sinorbit Academy, Sri Lanka.
Yes. And to all of you listening, especially those of you gearing up for exams, maybe even contract law exams, we want to wish you the very, very best of luck.
You've got this. You've put the hours in. Good luck.
Okay, so contract law talks about 4 main ways a contract can end or be discharged.
Right. There's performance, which we've mentioned. Then agreement between the parties. Breach, our other focus today. And finally, frustration. That's when some unexpected event makes the whole thing impossible or radically different.
We'll definitely tackle frustration another time. It's a fascinating area. But today, it's all about performance and breach.
And it's worth remembering, as the source materials point out, breach is often just, well, defective performance, isn't it? They're very closely linked.
They really are. So our mission today, to take these concepts, these principles, unpack them, look at the key cases the University of London materials highlight, and help you build a really solid understanding.
Understanding what performance actually requires, what happens when it goes wrong, what counts as a breach, and crucially, what the innocent party can do about it.
This is vital stuff, especially, as we said, if you've got exams coming up.
Okay, let's start with the ideal scenario then. Discharge by performance.
The happy ending.
Exactly. In theory, it's the simplest way out. Both parties do exactly what they promised, contract fulfilled, done.
But, as always in law, even the simple stuff can have twists. The source materials introduce a really critical idea here, entire obligations.
Yes, this is a really important concept to grasp. An entire obligation. What does that mean?
It sounds, well, entire.
Pretty much. It means one party has to perform their side of the bargain 100% completely before they have any right to get paid or receive the other party's performance.
So no part payment for doing part of the job.
Under a strict entire obligation. Nope. You finish it all or you get nothing.
Wow. That sounds potentially harsh.
It can be incredibly harsh. And the classic case, the one everyone remembers, is Cutter v. Powell. It's from 1795.
Cutter v. Powell. Okay, tell us about it.
Right, so the facts. Mr. Cutter, a sailor, agrees to be second mate on a ship sailing from Jamaica to Liverpool.
Okay.
The deal was he'd get paid a lump sum, a decent amount for the time, 10 days after the ship arrived at Liverpool. But here's the crucial bit. Payment was provided, he completed the whole voyage, and did his duty all the way to Liverpool.
Ah, the condition. The entire journey.
Exactly. So what happened?
I sense tragedy looming.
You guessed it. Mr. Cutter, poor fellow, died just a few days before the ship reached Liverpool. He'd done almost the entire voyage.
Oh, no. So his widow, she tried to claim payment for the work he had done.
Understandably, yes.
Yeah.
She sued for a proportion of the wages, arguing he'd done most of the work.
And the court's decision, based on this entire obligation idea.
Her claim failed, completely. The court said the contract was an entire obligation. Payment depended on completing the whole thing. Since he hadn't completed the entire performance specified serving all the way to Liverpool, The condition for payment hadn't been met.
So nothing, not even for the weeks and weeks he had served.
Nothing. It's a stark illustration.
Yeah.
Cutter v. Powell. Entire contract requires entire performance for payment.
That feels incredibly rough, especially given the circumstances. He was almost there.
It does. And it highlights why you need to be really careful if a contract seems structured like that. If payment is entirely dependent on 100% completion, that's a big risk.
Which is why, presumably, these sorts of pure entire obligations aren't that common in big commercial deals today.
Generally less common, yes. Especially for high-value projects. You usually see stage payments, installments linked to milestones, precisely to avoid this Cutter v. Powell harshness, though they definitely still exist, especially for, say, lump sum service contracts.
The source materials mention a more modern case too, Bolton v. Mahadeva, a domestic example.
Yes, Bolton v. Mahadeva from 1972. This involved installing a central heating system in someone's house. The price was £560.
And the court saw this as an entire obligation. Install the system, get paid £560.
That's how they interpreted it. Now, the contractor did install a system, but it was defective. Badly defective. It gave off fumes, didn't heat the house properly. The cost to fix it was about £174.
So on a £560 job, £174 to fix it. That's quite significant.
It is. And applying the entire obligation rule, because the performance wasn't complete, he hadn't provided a functional heating system as promised. The contractor couldn't recover any of the £560.
Wow. So defective performance under an entire obligation means potentially no payment at all. Bolton v. Mahadeva reinforces that.
Exactly. Defective can mean incomplete in the eyes of this rule.
Okay, so the rule is harsh. Cutter v. Powell shows that. How does the law soften this? There must be ways around it if someone does, say, 95% of the work perfectly.
Absolutely. The courts and Parliament have recognized the potential unfairness. There are several ways the strictness of the entire obligation rule is mitigated in practice.
Right, let's go through these mitigation methods. What's the first one?
The first is simply down to how the courts interpret the contract.
So they might just decide it's not one big entire obligation.
Precisely. They might look at a complex contract and say, actually, this isn't one single task. It's a series of smaller, distinct obligations or stages.
Like building a house in phases. Foundations, walls, roof.
Exactly. And if the contract can be interpreted that way, then completing a specific stage might trigger the right to payment for that stage, even if the whole project isn't finished yet. It allows for payment as you go.
Okay, breaking it down, that makes practical sense. What's next?
This next one is really, really important. It comes up all the time. It's the principle of substantial performance.
Substantial performance.
Okay, this applies when a party's performance isn't perfect, isn't 100%, but it's close enough to be considered substantial.
So they've basically done the main part of the job, maybe with a few minor issues.
That's the idea. If the performance is deemed substantial, then the party can recover the contract price. But there's a catch.
They don't get the full amount.
Correct. They get the contract price minus a deduction for the cost of fixing the minor defects or omissions.
So you get paid, but the other party gets compensated for having to put the small things right.
Exactly. The idea is, if the breach is minor, just a warranty breach or a non-serious breach of an intermediate term, it doesn't go to the root of the contract. So the performing party shouldn't lose everything. They get paid, less the cost of cure.
This sounds much fairer. Is there a key case for substantial performance?
Yes. The go-to case is Honig v. Isaacs, 1952.
Honig v. Isaacs. Tell us about it.
It involved decorating a flat. Contract price was £750. The decorator finished the job, but there were a couple of minor problems.
Like what?
A wardrobe door needed replacing, and a bookshelf needed a bit of fixing up. The cost to sort these out was estimated at $55.
Okay, $55 up on a 750-pound job seems relatively minor.
That's what the court thought. They held that the decorator's performance, despite these small defects, was substantial. The main job was done.
So, applying the principle.
The decorator was entitled to the £750 contract price, but minus the $55 needed to fix the defects. So he recovered $695. Honig v. Isaacs is your classic example. Substantial performance means you get the price, less the cost to remedy minor defects.
But I can see the arguments here. How substantial is substantial enough? Where's the line between that and the Bolton v. Mahadeva situation where the defects were too big?
That's the million-dollar question, isn't it? It's a question of fact and degree in each case. You look at the nature of the defects, the cost of fixing them compared to the total contract price, and crucially, the purpose of the contract. Was the performance fundamentally what was bargained for, just with minor flaws, Honig? Or was it fundamentally defective, Bolton?
So it's a judgment call for the court. Tricky.
It can be. That's where disputes often arise.
Okay, so we have interpretation into stages and substantial performance, Honig v. Isaacs. What other ways does the law help?
There are also specific statutory exceptions. Legislation sometimes steps in.
In sale of goods.
Exactly.
Yeah.
The Sale of Goods Act, 1979, Section 32A, deals with delivering slightly the wrong quantity to a non-consumer buyer. If the shortfall or excess is so slight that it would be unreasonable for the buyer to reject the whole lot,
They can't reject it just for that tiny quantity difference.
right, they generally have to accept the goods and pay, probably with the price adjustment. It stops buyers using trivial quantity errors to get out of a deal they regret for other reasons.
Makes sense. And for consumers.
The Consumer Rights Act, 2015, Section 25(1), has a similar idea. If a trader delivers the wrong quantity and the consumer accepts them anyway, the consumer has to pay for what they accepted at the contract rate.
Okay, specific laws for specific situations. What's the last main way to mitigate the entire obligation rule?
This involves acceptance of partial performance.
So the innocent party actually agrees to take the incomplete work.
Yes, but crucially, they must have a genuine choice in accepting it. If one party only performs part of their job and the other party voluntarily accepts that partial performance, then the performing party might be able to claim payment for the benefit they've provided, usually on a quantum meruit basis as much as deserved.
Okay, voluntary acceptance. What does that mean in practice? Is there a case on this?
There is, and it really clarifies the choice element. It's Sumter v. Hedges from 1898.
Sumter v. Hedges. What happened there?
A builder agreed to build 2 houses and stables for a landowner. Lump sum payment on completion sounds like an entire obligation. The builder did about half the work, then ran out of money and just abandoned the site. He left some building materials behind.
So the landowner is left with half-finished buildings. What did they do?
Well, they wanted the buildings finished, so they completed the work themselves using the materials the builder had left.
Right. So did the builder argue the landowner had accepted his partial work by finishing the job and using his materials?
He tried to argue that yes. He wanted payment for the work he had done and for the materials used.
And
The court said no. He couldn't recover anything for the work done. Why? Because the landowner didn't really have a voluntary choice.
how so?
The buildings were on his land. What else was he supposed to do? Leave them half-finished indefinitely? The court said finishing the work wasn't a free choice. It was the only practical option. Therefore, it wasn't acceptance in the legal sense required to trigger payment for partial performance.
Ah, I see. So for acceptance of partial performance to work, the innocent party needs a real alternative. They can't be sort of forced into taking the benefit. Sumter v. Hedges makes that clear. Acceptance requires a genuine choice.
Exactly. You can't just leave half a house on someone's land and say, well, you used it, so pay me.
The source mentions the Law Commission wasn't entirely happy with the Sumter v. Hedges outcome.
That's right. They thought the real choice requirement might be a bit too strict and suggested a broader right to recover if a benefit was clearly accepted, even without that free choice. But that specific proposal hasn't become general law, although consumer law has moved a bit in that direction.
Okay, let's quickly recap performance. The default, especially for entire obligations, Cutter v. Powell, is 100% completion needed for payment. But this is softened by interpreting contracts in stages, the vital principle of substantial performance. Honig v. Isaacs payment minus cost of minor defects, specific statutory rules, like Sale of Goods Act, and acceptance of partial performance, but only if the acceptance involves a real choice. Sumter v. Hedges. Substantial performance seems key.
That's a great summary. Now, let's pivot to when things definitely go wrong. Discharge by breach.
Right. This happens when a party, without a valid legal excuse, just fails to do what they promised.
Or they do it badly defective performance.
Yeah.
Or they signal they're not going to do it.
And we're focusing first on actual breach, right? Where the performance deadline is hit and nope.
Exactly. The time for performance is now, and the performance is either missing or incorrect. We'll get to anticipatory breach, the before it's due scenario, later.
So, actual breach. Performance due but not delivered properly. How do we figure out if a breach has actually happened and, crucially, how serious it is?
It boils down to looking closely at the specific contractual term that's been broken. 2 key questions. First, what standard of performance was required by that term? Second, what type of term was it?
Standard of performance. The sources mention 2 main ones: strict liability and reasonable care and skill. Let's start with strict liability.
Okay. Strict liability is exactly what it sounds like. It's tough. The performance must match the contractual requirement precisely.
No excuses. Doesn't matter if you tried hard or if it wasn't really your fault.
Nope. Fault is irrelevant. Effort is irrelevant.
Yeah.
If you promise to deliver X and you deliver Y or X with a tiny flaw, you're in breach. Full stop.
Where does this strict standard usually apply?
It's very common in contracts for the supply of goods. Think about it. When you buy goods, you expect them to be exactly as described, fit for purpose, satisfactory quality. Those promises are usually strict ones.
Is there a case that really hammers this home?
Absolutely. Arcos v. Ronison, 1933.
A classic. Arcos v. Ronison. What were the facts?
A contract for wooden staves, the kind used to make barrels. The contract specified the thickness. They had to be half an inch thick. That's 816ths of an inch.
Okay, very specific. And what was delivered?
Staves that were mostly fine but varied slightly in thickness. Some were 716ths, some 9 or 16ths. Tiny variations.
But could they still be used to make barrels?
Yes. Perfectly usable for the intended purpose. And the seller wasn't really at fault. Timber naturally varies a bit.
So commercially fine, no fault. But technically not exactly half an inch.
Precisely. And the court, applying strict liability, said, breach. The goods did not correspond exactly with the contractual description.
Even though the difference was tiny and didn't affect usability?
Even so, Arcos v. Ronison shows that strict liability means precise conformity. Performance must match to the description exactly. Fault doesn't matter.
Got it. Strict liability for goods. Match the description, period. The Sale of Goods Act backs this up too, right?
Yes, key implied terms in the Sale of Goods Act about description, quality, fitness for purpose, those are generally strict obligations on the seller.
Okay, what's the other standard? Reasonable care and skill.
This is a less demanding standard. It usually applies to contracts for the supply of services.
So here, the person providing the service isn't guaranteeing a perfect outcome.
No, they're promising to perform the service with the level of care and skill that a reasonably competent professional in that field would exercise.
So to prove a breach here, you have to show they were negligent, they didn't act reasonably.
Exactly. Fault is relevant here. You need to show they fell below the expected standard of care for someone doing that kind of work.
Like a doctor or a lawyer or an engineer, they promise skill, not a guaranteed cure or outcome.
Precisely. And again, there's statutory backing. The Supply of Goods and Services Act, 1982, implies a term that services will be carried out with reasonable care and skill.
Okay, so step one in analyzing a breach. Was the obligation strict, Arcos v. Ronison, or did it just require reasonable care?
That's the first part. The second part, equally vital, is looking at the type of term that was actually breached.
Back to our friends. Conditions, warranties, and intermediate terms.
Exactly those. Remember that classification. Condition, major term. Warranty, minor term. Intermediate or innominate term. Somewhere in between, where the consequences depend on how serious the breach actually is.
And why is this classification so critical when a breach occurs?
Because it determines the remedies available to the innocent party. Specifically, it determines whether they have the right to terminate the contract to walk away from future obligations.
Okay, so how does it work?
Only the breach of a condition, or a breach of an intermediate innominate term that is sufficiently serious, that goes to the root of the contract, gives the innocent party the right to terminate. This kind of breach is called a repudiatory breach.
So breach of condition, always repudiatory.
Yeah.
Breach of intermediate term, repudiatory if it's serious enough.
Correct. Think Hong Kong's shipping for that seriousness test with intermediate terms.
And what about breach of a warranty, a minor term?
Breach of warranty never gives the right to terminate. It only gives the innocent party the right to claim damages for the loss caused by that minor breach. The contract itself continues.
Right, so you can sue for damages, but you still have to perform your side of the deal.
Exactly. And this is crucial. If you wrongly treat a breach of warranty or a minor breach of an intermediate term as if it were repudiatory and you try to terminate.
You could end up being the one in repudiatory breach.
Precisely. It's a dangerous mistake to make. So nailing the term classification, condition, warranty, or intermediate is absolutely critical to knowing whether you have that powerful right to terminate.
That link between the type of term breached and the right to terminate is fundamental then.
Absolutely fundamental.
Okay, let's try applying this. Activity 12.1 in the source materials gives a scenario. Mountain Magic Ltd. is buying a mountain. Sounds exciting. Payment of £10 million is due at 5 p.m. December 3rd at the vendor's office. Their rep gets delayed by a bomb scare, arrives at 8 p.m. Is this a repudiatory breach?
Right, let's break it down. Standard of performance first. Paying money by a specific time and place.
Sounds strict to me. 5 p.m. means 5 p.m. The bomb scare, while unfortunate, doesn't change the fact they didn't meet the standard.
I agree. It's almost certainly a strict liability obligation. Performance didn't happen at 5 p.m., so a breach occurred. Now, the second question, what type of term is this time clause for payment?
In big commercial deals, aren't time clauses often seen as critical conditions?
Very often, yes. Courts tend to treat time as of the essence, meaning it's a condition, in commercial contracts because certainty is so important, even if it were somehow argued to be an intermediate term.
Being 3 hours late with a 10 million payment seems pretty serious, doesn't it? The consequences are significant.
Absolutely. The failure to pay is total for those 3 hours. So whether it's a breach of condition or sufficiently serious breach of an intermediate term, the outcome is likely the same. It's a repudiatory breach. The vendor likely has the right to terminate.
Okay, what if the rep arrived at 5:10 p.m., 10 minutes late? Still a breach of the strict standard, right?
Yes, technically still a breach because it wasn't 5 p.m. exactly.
But is it repudiatory? Would a 10-minute delay on a 10-meter payment be considered serious enough to justify terminating the whole deal?
Probably not. That's where the seriousness test for intermediate terms really comes into play. A court would likely say a 10-minute delay, while a breach allowing for minor damages, maybe interest, doesn't deprive the vendor of substantially the whole benefit of the contract. So, likely a breach, but not repudiatory.
And if Mountain Magic called ahead to explain about the bomb scare, does that change the breach?
Legally, probably not the fact of the breach itself if the obligation was strict, 5 p.m. was missed. But communication is always sensible. It might influence how the parties decide to proceed, perhaps leading to a waiver or a variation, but it doesn't undo the breach of the strict time term.
It really shows how you need both parts. The standard, strict versus reasonable care, and the term type, condition warranty intermediate, to work out if there's been a breach, and crucially, if it's serious enough to be repudiatory.
That's the analytical framework. Standard plus term type plus seriousness for intermediate terms, consequence, terminate, damages only.
Okay, we know how to spot an actual breach. What happens next? What are the consequences when a repudiatory breach occurs?
This is a really critical point, often misunderstood. A repudiatory breach does not automatically kill the contract.
It doesn't. Even a really serious breach?
No, the contract doesn't just evaporate. This was confirmed in UoL SAV International Practitioners in Marketing. Instead, the repudiatory breach gives the innocent party a choice, an election.
An election between what?
They can either choose to terminate the contract, accept the repudiation and treat the contract as discharged for the future, or they can choose to affirm the contract, meaning they disregard the breach for termination purposes and keep the contract alive.
So the power lies with the innocent party. Terminate or affirm.
Exactly. The choice is theirs.
Let's take termination first. If I choose to terminate because of their repudiatory breach, what happens?
If you elect to terminate, the contract ends prospectively. That means from the moment of termination onwards.
So future obligations disappear for both sides.
Correct. Neither party has to perform obligations that were due after termination. But, and this is important, any rights or obligations that had already unconditionally arisen before termination remain enforceable.
Well, like if they owed me payment for work I'd already completed before I terminated.
Yes, you can still claim that payment. The contract has a past, but no future. Lord Porter in Heyman v. Darwin's put it nicely, and it was reinforced in Johnson v. Agnew. Termination for breach is prospective. Past rights remain, future obligations cease.
And damages. Do I still get damages if I terminate?
Yes. Regardless of whether you terminate or affirm, if you've suffered loss because of the breach, you almost always have the right to sue for damages to compensate for that loss.
Okay. Now, the source materials highlighted something really important about the type of damages you can get, especially loss of bargain damages.
Ah, yes, this is a crucial distinction, especially after a recent case. Loss of bargain damages are basically compensation for the profits you expected to make over the entire life of the contract if it had been fully performed.
Right, the big money, potentially.
Exactly. And the general rule, clarified significantly by Phone's 4U Ltd VEE Ltd in 2018, is that you can usually only claim these full loss of bargain damages if you terminate the contract based on a common law repudiatory breach.
Meaning a breach of condition or a serious breach of an intermediate term recognized by the general law.
Correct. If, instead, you terminate the contract simply by using an express termination clause that's written into the contract itself.
Well, like a clause saying party A can terminate if event X happens.
Then you generally cannot claim those full loss of bargain damages, even if event X also happens to be a common law repudiatory breach.
Wait, seriously, so how I frame my termination matters enormously for the amount of damages I can recover.
It seems so, based on phones 4U VEE. In that case, phones 4U terminated using an express clause in their contract with EE. They then tried to claim around $200 million for the lost future profits.
And the court said no.
The court said no to the loss of bargain damages because they had terminated under the specific contractual clause, not for a common law repudiatory breach. Their damages were limited to what the contract clause allowed, or general damages not based on losing the whole future bargain.
Wow. Okay, phones for you VEE is a massive warning. The basis for your termination, common law repudiation versus express contractual clause, can have huge financial consequences, specifically regarding loss of bargain damages. That's vital for practice.
Absolutely vital. You need to be very clear why you are terminating.
What about the party who actually committed the breach? Can they still sue on the contract?
Sometimes they can't. If the obligations are dependent, meaning Party A has to perform before Party B has to perform, then if Party A breaches their prior obligation, they generally can't sue Party B for not performing theirs later. We saw that with entire obligations.
It makes sense. If I decide to terminate, how do I actually do it? Do I need to send a formal letter?
You need to communicate your decision to terminate clearly to the party in breach. This was established in Vital SA v. Norolf Ltd. It doesn't have to be a specific form. It could be words or conduct, but it must be unambiguous. They need to know you're treating the contract as over.
What if the breaching party tries to fix the problem after they breach, but before I've decided whether to terminate?
Ah, that's relevant. A court might look at whether the breacher was effectively cured before the innocent party made their election. If the problem was fixed quickly, it might influence whether a later attempt to terminate is seen as valid. Ampurious New Homes Holdings, Ltd v. Telford Homes, touched on this.
Okay, that covers termination. What if I, as the innocent party, choose the other option? What if I affirm the contract?
Affirmation means you choose to keep the contract alive, despite the repudiatory breach. If you affirm, both parties remain bound by all their contractual obligations, past and future.
So, business as usual?
Pretty much. But there's a significant consequence, particularly regarding anticipatory breaches, which we'll discuss more soon. If the other party signals they won't perform in the future, anticipatory breach, and you affirm the contract anyway.
I can't then change my mind later and terminate based on that original signal?
Generally, no. Once you've affirmed in the face of that specific anticipatory repudiation, you lose the right to terminate based on that same repudiation when the performance date actually arrives, or before it arrives if you've affirmed. Cases like Stocnia Gdanska, SAV Latvian Shipping Co., and the Fortune Plum make this clear.
So affirmation is a binding choice for that particular breach event.
Yes, although the Fortune Plum added a wrinkle. If the party continues their refusal to perform after you've affirmed, you might then be able to terminate based on that ongoing repudiation.
Okay. The source also mentioned affirmation in employment contracts, citing Gaze v. Societe Generale.
Yes, the Supreme Court confirmed that even in employment, where termination is often complex, the innocent party, the employee in that case, might still have the right to affirm the contract after the employer's repudiatory breach, depending on the circumstances.
Let's quickly look at activities 12.2 and 12.3. Activity 12.2 asks, what counts as affirmation, and is the choice limited by reasonableness?
Affirmation needs to be clear. It can be explicit words, I affirm, or conduct that is totally inconsistent with termination, like demanding future performance, accepting performance after the breach, or sometimes even just delaying the decision for too long. As for reasonableness, while the choice itself, terminate or affirm, is generally the innocent party's, the consequences of affirming, especially affirming an anticipatory breach and insisting on performing, are limited by reasonableness, as we'll see with the White and Carter qualifications.
And Activity 12.3 revisits why classifying the term, condition, warranty, intermediate is so important.
We keep coming back to this because it's central. It's crucial because it dictates whether you get the big weapon, the right to terminate, get the classification wrong, terminate when you shouldn't, and you're in breach, Decro Wall. It also affects your right to full loss of bargain damages, phones for you. So understanding term classification is absolutely key to knowing your strongest remedies.
Term classification is the gateway to the termination right. Got it.
Exactly.
Okay, we've covered actual breach, performance due, but fails. Now, what about the scenario where the failure is signaled before the performance is even due?
Ah, yes. This is anticipatory breach. A breach that occurs in anticipation of the performance date.
How can you breach before you're supposed to do anything?
It happens in one of two main ways. as clarified in Spar Shipping ASV Grand China Logistics. Either a party clearly states or indicates they won't perform when the time comes, or they do something that makes it impossible for them to perform later.
So words or actions that preemptively break the promise?
Precisely. The first way is renunciation. This is where one party makes it clear through words or conduct that they have no intention of performing their side of the bargain when it falls due. The test is objective. Would a reasonable person conclude they're refusing to perform?
A clear, I'm not going to do it.
Or actions that clearly imply that. The second way is disabling oneself.
Making it impossible to perform later.
Yes, where a party acts in such a way that they put performance beyond their own power. And interestingly, as the source notes, fault isn't the issue here. If you disable yourself, you disable yourself.
Is there a case example for disabling?
Universal Cargo Carrier's Cor Visitati is a good one.
Mm-hmm.
A charterer was meant to provide cargo for a ship by a certain date.
Okay.
He couldn't get the cargo ready in time because his own supplier let him down. It wasn't directly his fault the supplier failed.
But the result was he couldn't load the ship when required.
Exactly. By not having the cargo, he had effectively disabled himself from performing the loading obligation. The court held this was an anticipatory breach by disablement, even though the root cause was a third party's failure.
Right. So Universal Cargo Carrier's Visitati. Disabling yourself is anticipatory breach regardless of fault. The effect is what matters.
And here's a key feature of anticipatory breach. It gives the innocent party an immediate right of action.
Immediate. You don't have to wait until the actual performance date that they've said they'll miss.
No waiting required. The moment they commit the anticipatory breach, by clear renunciation or disabling themselves, you can choose to accept that breach and sue them immediately.
And claim damages straight away.
Yes. And crucially, damages are assessed based on the date the anticipatory breach occurred, not the future date when performance should have happened. This principle comes from the very important case of Hochter v. Latour, 1853.
Hochter v. Latour. Anticipatory breach gives an immediate right to sue and claim damages assessed at the time of the breach. That's powerful.
It allows the innocent party to mitigate their losses sooner and get certainty.
Does any indication of future non-performance count as a repudiatory anticipatory breach, allowing termination?
No. Just like actual breach, the anticipated failure must be serious. The likely effect of the non-performance, when the due date arrives, must be equivalent to a breach of condition or a serious breach of an intermediate term.
So, if they renounce, the renunciation has to be clear and relate to fundamental obligations.
Yes. Passing that reasonable man test, does it show an intent not to perform the core of the contract?
And if it's prospective inability or disablement?
You look ahead. How serious will the consequences of this inability be when performance is due? If those consequences would be repudiatory then, the anticipatory inability is repudiatory now.
So, facing a repudiatory anticipatory breach, the innocent party has that same election again. Terminate now or affirm?
Exactly the same choice. Terminate immediately based on the anticipatory breach, Hoster v. Latour, or affirm the contract and wait for the performance date.
And if they choose to affirm, this brings us to that very famous case.
It does indeed. Affirming an anticipatory breach leads us straight to White and Carter Counsels, Ltd v. McGregor, 1962. A landmark and sometimes controversial decision.
White and Carter v. McGregor. Let's unpack it. What happened?
White and Carter were advertising contractors. They made a deal with McGregor, a garage owner, to advertise his garage on litter bins for 3 years.
Okay, a 3-year advertising contract.
But on the very same day the contract was signed, McGregor's representative called White and Carter and said, actually, we've made a mistake. We don't want the advertising. Cancel the contract.
Wow. Immediate repudiation. A clear anticipatory breach by renunciation.
Absolutely clear. So White and Carter, the innocent party, had the option to accept that repudiation, terminate, and sue for damages. Probably lost profit.
But they didn't do that.
No. They refused to accept the cancellation. They chose to affirm the contract. They then went ahead, made the advertising plates, put them on the bins, and displayed the ads for the full 3 years, even though they knew McGregor didn't want them.
They performed their side anyway.
They did. And then they sued McGregor, not just for damages, but for the entire contract price for the 3 years of advertising.
And the House of Lords said they could do that. Claim the full price for unwanted performance.
Yes, by a majority. That's the White and Carter principle. The innocent party faced with an anticipatory repudiation can, in certain circumstances, affirm the contract, continue to perform their own obligations, if possible without the other party's cooperation, and then claim the full contract sum as a debt, rather than suing for damages.
That seems quite extreme. You can just ignore the other party wanting out and force the performance on them.
It feels counterintuitive sometimes, doesn't it? But the logic is that the contract remains valid until the innocent party chooses to terminate it. However, this right to affirm and perform is not absolute. There are crucial limits.
Ah, the qualifications. Lord Reed mentioned these in his judgment.
Yes, Lord Reed identified two important limitations. And later, McGarry J. in Hounslow LBC v. Twickenham Garden Developments Ltd. argued these weren't just side comments, but part of the actual binding reason the ratio of the White and Carter decision.
Okay, what are these two vital qualifications that limit the White and Carter principle?
Qualification number 1. The innocent party cannot affirm and continue performance if they need the cooperation of the breaching party to do so.
So if my performance requires them to actively do something, or give me access, or provide information, and they refuse because they've repudiated,
Then you generally can't affirm and perform. You're stuck. You'll likely have to accept the repudiation and sue for damages instead. The Hounslow LBC case involved builders needing access to a site, which was denied. They couldn't force their way on to perform.
right, that makes practical sense. You can't compel cooperation. What's the second qualification?
Qualification number 2. The innocent party cannot affirm and continue performance if they have no legitimate interest in doing so, other than claiming the contract price.
No legitimate interest. What does that mean?
It means you can't insist on performing if doing so is, frankly, completely pointless or commercially unreasonable, and your only real motive is to avoid having to prove your losses and mitigate, potentially sticking the other party with a much bigger bill, the full price, than damages would be.
So if continuing performance is wholly unreasonable?
Yes, that phrase comes from cases like the Odin Field and the Alaskan Trader. Or perverse, as suggested in the Aqua Faith. If performance serves no useful purpose for you and is vastly more costly for the breaching party than damages would be, the court might say you have no legitimate interest in affirming and performing. You should just accept the breach and sue for damages.
Okay, so the White and Carter principle lets you affirm an anticipatory breach, perform, and claim the price. BIVUT only if, 1, you don't need the breaching party's cooperation, Hounslow LBC, and 2, you have a legitimate interest in performing. It can't be wholly unreasonable or perverse. Odenfield, Alaskan Trader, Aquafaith, those qualifications are key checks and balances.
They are absolutely crucial limitations on what could otherwise be a very harsh principle.
What are the risks, then, for the innocent party if they do choose to affirm an anticipatory breach? It sounds like it might not always be the best move.
There are definite risks involved in affirming. A major one is frustration.
How does that work?
Okay, imagine the other party repudiates in June for a performance due in December. You decide to affirm, keep the contract alive. Then, in October, something completely unexpected happens. Say, the venue for the December event burns down, or a new law makes the performance illegal.
Frustrating event.
Exactly. If a frustrating event occurs after you've affirmed but before the original performance date, the contract is discharged by frustration.
And what happens to my original claim based on their June repudiation?
It disappears. It's extinguished by the frustration. You lose the right to sue for that earlier anticipatory breach. The classic case illustrating this risk is Avery v. Bowden. Affirming risks losing your claim if frustration intervenes. Avery v. Bowden.
Wow, that's a huge risk. You affirm hoping they'll perform, but then an external event kills the contract and your claim.
It's a gamble. Another risk is that if you affirm, the contract stays alive for both parties. If you then subsequently breach the contract yourself before the original performance date.
I can't then turn around and rely on their earlier repudiation.
Generally not. You've kept the contract alive, so you're still bound by it too.
Okay, let's use the activities again. Activity 12.4 asks about Meggery J's view in Hounslow, were Lord Reed's qualifications really part of the ratio of White and Carter?
It's a classic legal debate. Technically, parts of Lord Reed's speech might be OBR, said, by the way. But Meggery J argued forcefully that the principle only makes sense and achieves justice with those qualifications. He saw them as inseparable from the core ruling. It shows how judges shape the law by interpreting not just the strict outcome, but the underlying reasoning and practical implications of earlier cases.
Activity 12.5 links directly to the legitimate interest point. Can you insist on performing if it's just wasted effort?
Exactly. This probes that second qualification. If your continued performance is genuinely pointless, serves no commercial purpose for you, incurs significant wasted cost, and seems primarily aimed at maximizing the bill for the other party.
A court is likely to say you have no legitimate interest.
Very likely. They'll say you should have accepted the repudiation and mitigated your loss by claiming damages instead. Cases like Cleese Shipping v. Bulk Oil explore this. Was there a rational commercial reason to continue?
And Activity 12.6 flips it. What are the risks of not accepting an anticipatory repudiation, i.e., the risks of affirming?
It's basically asking for a summary of the downsides we just discussed.
Yeah.
Risk 1. The contract might be discharged by frustration later, wiping out your claim. Avery v. Bowden. Risk 2. You might breach the contract yourself later and lose the right to rely on their earlier breach. Risk 3. You commit yourself to potentially performing your side, possibly unwantedly, subject to the qualifications.
Okay, fantastic. We've covered a lot of ground. Performance, entire obligations, substantial performance, actual breach standards and types, consequences like termination and affirmation, anticipatory breach, White and Carter, and its vital qualifications. Let's try and pull this together, especially thinking about exams.
The source material's examination advice is spot on. Questions love testing your grasp of the nature of terms, condition, warranty, intermediate, and the consequences of breach. Knowing when you can terminate and why is key. Damages often feature too, but we focused on the right to terminate and claim damages today, not the calculation details.
Let's use sample question 1 from the advice. When a party has a right to terminate a contract for breach is far from clear and should be clarified. Discuss. Why is it often unclear?
The main culprit is the intermediate or innominate term. For conditions, breach means terminate. For warranties, breach means damages only. Simple. But for intermediate terms, you only get to terminate if the breach is serious enough in its consequences.
The Hong Kong fur shipping test.
Exactly. And judging seriousness is inherently uncertain. It depends on the facts, the impact of the breach. You often don't know for sure if a breach is repudiatory until a court tells you later.
Which creates risk for the innocent party deciding whether to terminate now.
Huge risk. If you terminate thinking the breach is repudiatory, but a court later disagrees and says it was only minor, then your termination was wrongful, and you are in repudiatory breach. Remember Decro-Wall.
So the lack of clarity comes mainly from assessing the seriousness of intermediate-term breaches. The exam advice prompts thinking about improvement.
Yes. Could legislation help by defining more terms up front? Would that be too rigid? Should courts focus more on what the parties said a term was? Should parties just draft their contracts much more clearly by the consequences of specific breaches? It encourages critical thinking about the law's practical effects.
Okay, let's really test our application skills with sample question 2, Rhonda the plumber. This looks like it pulls everything together.
It's a great scenario. Let's walk through it. Rhonda hired by Simon, 10-K job, finished by December. November comes, she hasn't started. Simon hears she's on another big job.
Simon concludes she can't possibly do both. So he calls her office, says don't bother, and hires Amanda instead for $15K.
Right. First question. Was Rhonda in anticipatory breach before Simon called? He concluded she couldn't perform. But did she renounce? No, she didn't say she wouldn't do his job. Did she disable herself? Applying universal cargo carriers, would a reasonable person objectively conclude she could not perform both by December? Simon didn't make further inquiries. It's highly debatable whether her taking another job was, at that specific moment, a clear repudiatory anticipatory breach. Maybe a potential breach, but arguably not clearly repudiatory yet.
So if Rhonda wasn't definitely in repudiatory breach, what's the effect of Simon telling her don't bother?
That sounds very much like a clear statement that he will not accept her performance. That looks like a repudiatory anticipatory breach by renunciation.
Yeah.
By Simon.
The tables have turned. Simon might be the one who repudiated first.
Quite possibly. So, Rhonda now faces Simon's repudiation. What are her options?
Terminate and sue Simon for damages. Or affirm.
Right. What does she do? She drops the other job to free herself up for Simon's more lucrative one. This looks like she's trying to affirm Simon's contract.
She wants to perform despite his don't bother message. Can she do this under White and Carter v. McGregor?
Prima facie, yes. The principle allows affirmation and performance. But we need the qualifications.
Qualification 1, need for cooperation. Does she need Simon's cooperation?
Yes, definitely. She needs access to his restaurant to do the plumbing. So the Hounslow LBC qualification kicks in. If Simon actively denies access, she probably can't perform.
But Simon's on vacation. His staff let her in.
And this is the tricky bit, as the source implies. Do the staff actions count as Simon providing cooperation, overcoming the Hounslow barrier? Or does cooperation need to come from Simon himself? It's arguable. If access was effectively granted, maybe she could legitimately affirm and perform.
While this is happening, Simon's definitely breached his contract with Amanda by preventing her access.
Oh, yes. Amanda has a clear claim against Simon for breach of her 15K contract. He owes her damages.
And Rhonda finishes the job and sends Simon a bill for £10 K. Can she claim it?
Her claim for the 10-count case depends entirely on whether her affirmation was valid. If Simon's initial "don't bother" was a repudiatory breach, and if she was entitled to affirm, navigating the cooperation issue via the staff letting her in, then under White and Carter, she might be able to claim the full price. If her affirmation wasn't valid, perhaps because staff access wasn't sufficient cooperation, then her only remedy against Simon would likely have been damages for his repudiation, which she would have had to mitigate. It's complex.
That scenario really highlights how you have to trace the steps, identify each potential breach, apply the principles of repudiation, election, affirmation, White and Carter, the qualifications. It's a real workout.
It perfectly demonstrates the interconnectedness of these concepts and the need for careful, step-by-step analysis using the case law.
So if you're studying for an exam, let's quickly list the absolute key takeaways, the must-knows from today.
Definitely need to know. Entire obligations, Cutter v. Powell. Substantial performance, Honig v. Isaacs. The difference between strict liability, Arcos v. Ronison, and reasonable care. Term classification, condition, warranty, intermediate, Hong Kong fur, and its link determination. Repudiatory breach gives an option, not automatic, Deckerel Wall. Termination is prospective, Heyman v. Darwin's, Johnson v. Agnew. Affirmation and its limits, Stosny-Aganska, Fortune Plum. Anticipatory breach, renunciation disabling spar shipping, Universal Cargo. The immediate right to sue, Hoster v. De La Tour. The White and Carter principle on affirming anticipatory breach. The crucial qualifications to White and Carter, Cooperation Hounslow LBC, Legitimate Interest Odenfield, Alaskan Trader Aquafaith, and the risks of affirming, Frustration Avery v. Bowden.
That's a solid checklist. If you can explain those concepts and cite the key cases, you're in a very good place.
It gives you the tools you need for analysis.
Well, what a journey that was. We really dive deep into how contracts meet their end, through the smooth path of performance and the rockier road of breach. We looked at the harshness of entire obligations, the relief of substantial performance, the standards required, why classifying terms is so vital, and the whole complex world of anticipatory breach, including that fascinating White and Carter principle and its limits.
And understanding all this is just so important, whether you're facing an exam, running a business, or just signing an agreement. Knowing your rights and obligations when performance isn't perfect or looks like it might fail is crucial knowledge.
It really is. We've seen the law trying to balance sticking to the agreed terms with practical realities, which leaves us with a final thought for you to ponder. Does the current law, especially around terminating for breach, strike the right balance? Is it clear enough for people to act confidently? Or does the uncertainty, particularly around intermediate terms and anticipatory breach, create too much risk?
And just a reminder, this deep dive was based on the excellent materials made available by the University of London, and it's intended solely for educational purposes.
And it was brought to you with huge thanks to Sinorbit Academy, Sri Lanka. To everyone out there hitting the books for exams, one last time from both of us, good luck.
You can do it.
Thanks for joining us on the deep dive. We'll be back soon to unpack another complex topic.